And according to the prosecution, the defendants, there are two of them, Elaine Claremont not being tried right now, but also co-defendant, they wanted to get the media involved. They wanted to project their argument that the school is not safe enough. The prosecutors say that's how they did it. So let me talk to both of you, both former prosecutors here, all right? And Karen, I'm going to ask you to pick up the mantle, if you will, in this, because I'm sure a lot of our for a while. We'll get to the defense in a second. And Joanna, let me bring you into this conversation. We saw in the O.J. Simpson trial, the one that took place recently in Las Vegas, he was also charged with kidnapping. Yes. And people in the very beginning said, well, how can that be? They never took them out of the room, and the Las Vegas has this statute. Basically says if somebody feels that they can't leave, that can be kidnapping. Yes. Could that, you think, be enough at least to get the prosecution into that area in this case?
Well, it's a very subjective feeling, isn't it? It's how do I feel? If you block the door and I'm a very petite little thing and I feel I can't leave, boom. Now I could go to the police and say, you know, he didn't allow me to leave. The thing that's very surprising to me as we look at this case is that you have no lesser charges. All we have is we have extreme charges. We don't have endangering the welfare of a child, where you have they're holding a child for a period of time, where the prosecution could have gone, but they chose not to. They went to the whole other end of the spectrum, which what is the message that sent? Not help a child that's on the side of the road. I'm a mom. If I saw a child on the side, guess what? I'm pulled over.
You know what?
What about good Samaritan?
Hold your thought for 1 second, because you're setting me up for our conversation, which is the defense side. And let me get us to there, and then we'll pick up here, because the defense is saying exactly that. The defense is saying, wait a minute, she's acting as a good Samaritan. She's helping a child, a 6-year-old, wandering on the road by himself. Listen to some of what the defendant herself has to say. Saying this is what I was trying to do and why I was trying to do it. So, Joanna, come back to your point now. What you're saying, and cases send messages.
They do.
So what you're saying here, a message might be, don't help children?
Well, that's exactly what it is. See, I think, what I really think was in the prosecution's head is that we have so many children that at this time, we have Casey Anthony case that was going on. We have the Cantu case. We have so many cases going on of children that are missing of the same age that they're going, wait a minute, we want to do something about this. But they did one message of, we don't want children going missing. But then the message that comes out is, don't be a good Samaritan, don't help children. I was just at the park with my little kid. I saw a kid fall. His parents weren't there. You want to know something? I go over to the child to help pick him up. Yeah. Am I all of a sudden a bad person because I touched a child? Yeah. No, I'm being a good mommy going over to do that.
So if you look at this, I mean, there are conflicting messages coming out of the courtroom.
Yes, there are, but getting back to your point about why they charged it this way, I actually think that it makes perfect sense. Because at the end of the day, this is a law and order prosecution, and it's charged without lesser included. It's charged with the whole enchilada for a reason. Because if you have a law and order jury and they make out the elements and the child could not leave, and they can prove intent if that's a necessary element, then they have to convict.
See, I don't agree with that at all. I don't agree with that at all whatsoever.
But aren't you happy if you're the defense attorney that there isn't a lesser included here that could let the jurors say, oh, well,
yes, but this is what I don't agree with what you're saying at all whatsoever, is that you're forcing the jury to find not guilty. The reason why you're forcing the jury to find not guilty...
from the prosecutor's perspective, you're saying by not putting in a lesser. So the prosecutor doesn't want the lesser.
Correct. By not putting the...
Okay.
You're forcing the jury to find not guilty, because even, you're right, it is rules and regulations. It is if you make out the charge. But guess what? There's still human beings in a jury, and all of us who have been in front of a jury know that even if they make out the elements, they are still human beings. And you want to know something? A lot of them are going to be parents that are on that jury that are going to say, I'm going to pick up that kid.
Hold those thoughts, because I want to talk to both of you about what jurors, the impact of the conscience of the community working in this case, and what impact that might have. In any event, let's get back inside of the courtroom now, and that while we were in the midst of our commercial break, before we knew that the sentence is imposed, we all went around saying, what do we think the sentence is going to be? What would we do if we were the judges? So, 150 years. All right, let's start, and we'll bounce back and forth. Karen, I'll start with you for this. Does that surprise you? And how about you? Surprised by the number, 150 years?
Not at all. I'm not surprised at all, because he didn't do a plea deal, and he's not going to help any of these victims find any of their money. So because he's not going to be helpful in anything at all whatsoever, the judge had to make sure he was going to die in prison. And I am not surprised at all, because there were victim impact statements. I'm not surprised at all because, again, as we were just discussing, as the voice, if you will, of the community, even though there are guidelines at times that you could follow or not, I'm not surprised at all that it was this strong. However, what I do see is a bail pending an appeal application, potentially saying that the judge was extreme in what he did do with 150 and saying, hey, we were asking for 12, you gave me 150. Somewhere we're a little off, and probation said 50.
Yeah. Let me jump in for 1 second here. It's a live shot you're seeing right now outside of the federal courthouse in downtown New York City. Now, reminder for you, our own Gene Casares was inside. Want a reintroduction here, our friends that are spending some time with us in session. Joanna Greenwald, former prosecutor, currently a criminal defense civil attorney, and Karen Bitar, also a former prosecutor in Brooklyn, currently a securities litigator. So let's talk a little bit about this testimony before we jump back in. Laurinda Drake decides, I'm going to get on the stand. I want to tell my story. Is that as we know, rarely do defendants testify. There's some defense lawyers who say, I'll never put my client on the stand. Others take different approaches to it. Looking at this one, do you think this is the case where she has to testify?
I don't think that she has to, but I think it's a great idea that she does.
Right.
Because as we all know, as we are watching, that's just the prosecution's burden to prove the case. So that's why defendants don't have to take the stand. So the fact that she did take the stand, there must be something to it. And you want to know something? The more humanizing that they make her as a person, they make her into a mommy. And people who are jurors, and I always talk about the psyche of the jurors, you can relate to that if you are a parent, or if you're someone who cares about, or you're a person who's a good Samaritan type person.
Who's picked up their own children at a school sometime and sees somebody else. So is it then what she has to say, is her appearance and demeanor perhaps as maybe even more important than what she has to say?
I think it is, and I'll tell you why. I don't think the facts here are in dispute. Yeah. This is not a whodunit. This is not a what happened. It's why did it happen. And the only way to really explain that is to hear it from the defendant. Now, I agree, Joanna, she certainly doesn't have to take the stand. And it's a risky move if she takes the stand, because if she doesn't do well, if she doesn't seem believable, if she doesn't seem like a mother, she's cooked.
Yeah, but as you say, facts aren't in dispute. It's basically what was going on in her mind.
But the important thing, though, that you raised before when we talked about the kidnapping issue, we both talked about how it's subjective. She's also potentially the kidnapper, as opposed to the kidnappee. And is she this dominant personality that made this poor little child feel like this child could not leave and was no, is she coming off as a mom who was just there, who's trying to protect this poor child that was on a busy highway where there's a desert on the street? Remember, it's a subjective feeling.
How much do you tell her, and Karen, let me ask you this, how much do you tell her real quick before we get in about how she should act? I mean, do you say to her, get emotional, do you cry, or do you do something else?
The one thing I would say is whatever you do, don't lose your cool. Okay. Don't lose your temper. And keep your control when you're being cross-examined. And then obviously tell your story from your heart. If you're telling the truth, tell the truth.
Story. Well, she's on the stand
cry.
right now.
I say cry. I say cry all day long. Please cry. Cry a lot.
Strategically placed tears.
Crocodile tears.
In any event, Laurinda Drake back on the witness stand now, and again going through her story, her version of what it is that had happened, and most importantly,
I think that again, at this point, I do agree. She's presenting herself well. I would prefer tears, but she's presenting herself well with the correct amount of nervousness, as well as feelings of that she should have, maybe she would have done it slightly different, but she had good intentions. This was not someone who was looking to do something horrible.
Right, and as we know from the very beginning, what was in her mind at the time is going to be critical for this jury's determination here. All right, we're going to